Today we are going to talk about one of the most controversial, but impossible to avoid, Chief Justices in American history, Roger Brooke Taney. During his time on the Supreme Court, he deeply changed the balance between federal power and state power in the U.S. constitutional system. His judicial decisions did not just affect legal theory. They directly changed how the Constitution worked in real life and touched the most serious social conflicts of his time. Understanding Taney is not about judging him as a good or bad person. It is about seeing how judicial power can shape, speed up, or deepen national conflict at critical moments in history. This article focuses on his role in the development of the American constitutional system. Roger Taney, Judicial Power, States' Rights, and the Slavery Crisis. Roger B. Taney was one of the longest-serving and most controversial Chief Justices in American history. He led the Supreme Court from 1836 to 1864. After John Marshall had established federal supremacy, Taney steadily shifted constitutional interpretation toward states' rights first. On slavery, he tried to use judicial rulings to give a final answer. That directly changed the direction of how the U.S. Constitution worked in real life. And it even helped speed up the Civil War and the constitutional rebuilding that came after the war. Roger Brooke Taney was born in Maryland in 1777. His family was Catholic, in the Protestant mainstream society of that time. This kind of background could naturally create a certain caution toward majority politics. He tended to care more about legal limits, and he cared more about government not crossing the line into personal and local rights. Taney's early education lined classical. His legal training placed heavy weight on the common law tradition, property rights, and contract thinking, and it also valued a conservative sense of social order. When he was young, he had publicly criticized slavery, and he even freed some enslaved people he had inherited. But that did not mean he later became an abolitionist. Instead, he gradually became a law and order first figure. In his mind, the Constitution's most important job was not to clean up society morally, but to keep a divided union running with predictable order. The problem is that when the order itself is built on slavery as a structure, then pushing order first all the way ends up becoming a hard shield for an unjust structure. Taney entered the center of national power not by writing books or building academic fame, but by showing political execution ability. His real jump happened in the Andrew Jackson era. Jackson's political instinct was anti-elite, anti-financial oligarchy, and anti-national bank. He wanted to take economic power back from national financial institutions and return it to elected politics and local society. Taney played a key role in that fight. He first served as Attorney General, then as Secretary of the Treasury, carrying out Jackson's policy of pulling federal deposits out and attacking the second bank of the United States. From a constitutional perspective, that experience shaped Taney's basic instincts as a later Chief Justice. He deeply distrusted national financial power. He was extremely sensitive to federal power slowly expanding through economic and judicial channels. He was more willing to trust state governments and more willing to trust local legislatures to judge local public interests. So when he replaced John Marshall as Chief Justice in 1836, the Supreme Court's overall character changed with him. Marshall had turned the court into the main axis of the national machine. He emphasized federal supremacy, a national market, and a unified, expansive approach to constitutional meaning, because only that could keep a new country from breaking apart. Taney pulled the court to the other side. He emphasized states' rights, local room for public policy, and strict reading of federal power. In his view, federal power had to be read narrowly and could not grow without limit inside abstract words like convenience, need, or national interest. One of the earliest and most typical signs of this shift was the 1837 case Charles River Bridge v. Warren Bridge. On the surface, it was two bridge companies fighting over tolls and charter rights. But the real question was this: if the government gives you a charter, can you interpret it as an exclusive monopoly and lock down later public construction? Taney's opinion said that if the charter contract does not clearly say it is exclusive, courts should not assume the government has sold away future public interests. In other words, for public transportation and social development, the government can allow a new bridge even if it hurts the old bridge's profits. You can understand this as a kind of anti-monopoly instinct in judicial form. The law should not automatically lock the public sphere into early private business privileges. This also explains why many historians say the Taney Court was not always conservative on economic development. In some ways, it was even more willing to let democratic politics and public works break through old privilege structures. But the Taney era was not simply giving power to the states across the board. A more accurate description is that Taney used different logic in different areas to build a package. Limited federal power plus local self-rule plus stable private order. For example, in cases about banking, money and business regulation, the court often did not want the federal government to expand power through judicial interpretation. At the same time, on technical issues, it would still protect a kind of system stability, so the national market would not fall into total disorder. This tension ran through Taney's whole tenure. He wanted to limit the federal government, but he also could not let the union fall apart so much that it could not function. He wanted to respect states' rights, but he had to face the conflict points between state power and national unity. Because of this tension, his constitutional legacy looks complicated. It is not a simple story of pro-South or pro-federal. It is more like a constant fight between state-based political communities and the national constitutional framework. On the constitutional issue of power boundaries, another important set of Taney-era cases asked whether federal courts should step into political crises. The most famous is Luther v. Borden in 1849. Rhode Island was facing a constitutional mess over which government is legitimate, and the lawsuit tried to get the Supreme Court to decide who the lawful government was. The court refused to step in and said this was a political question that should be handled by the political branches. This decision is later seen as an important source of the U.S. political question doctrine. Not every constitutional dispute is suitable for courts to decide. If courts take over some disputes, it is like the judiciary choosing which regime is legitimate for the country, pulling the courts into a political swamp that cannot be cleaned up. Over the long run, this kind of restraint prevents courts from becoming tools of coups. But it also means that in the most critical conflicts over political legitimacy, courts may choose to step back. Sometimes stepping back is a stabilizer. In other times, stepping back leaves the conflict to be settled by harsher forces. In the same period, the Taney Court also left many influential decisions on commerce and federalism, such as Cooley v. Board of Wardens in 1852. It dealt with the relationship between state regulation of harbor pilot systems and federal power over commerce. The case developed a more detailed way of thinking. Some areas of commerce need national uniform rules, while others allow local solutions. If you translate that into constitutional language, it is answering how can a unified market and local self-rule exist at the same time. This idea later became part of what is called selective exclusivity and the dormant commerce clause. When Congress does not speak, can a state still regulate? In the Taney era, the answer often left more space for states, especially in areas that clearly had local features. The 1852 case Cooley v. Board of Wardens is a classic example. On the surface, the case was very specific. Pennsylvania required ships entering the port of Philadelphia to use local harbor pilots and pay related fees. The issue was that the U.S. Constitution gives Congress the power to regulate interstate and foreign commerce. So could a state still create this kind of port management rule? The Taney Court's answer was not a simple states cannot or states can. Instead, it introduced a layered test. Not every commercial matter has to be managed with one national rule. The court's point can be put in plain words like this. Some things naturally need one national standard, like basic rules for interstate trade. But some things clearly have local features, like waterways, harbor pilots, and dock order. Those are often better handled locally, based on local realities. This is where two later concepts come from. The Dormant Commerce Clause refers to a situation where the Constitution gives Congress power over commerce. But Congress has not passed a law yet, meaning it stays silent. So before Congress speaks, can a state regulate? In the Taney era, the answer was, if the field is clearly local in nature and does not need one national rule. Then before Congress steps in, the state can regulate. As for selective exclusivity, it does not mean exclusive monopoly. It means a selective rule of exclusion. Only in areas that truly need national uniformity is federal power exclusive, and states cannot interfere. In other areas that do not require one national approach, federal power does not automatically exclude state regulation. So the real importance of Cooley is not the port fee itself. It is that the court clearly told people this. The U.S. national market is not built by pushing all power up to the federal level. Instead, it allows a large amount of local governing space, as long as the overall market is not damaged. If you want one very direct sentence to summarize the Taney Court's attitude here, it is this: unity is not the default, and the center is not naturally all-powerful. Whether something should be unified depends on whether the matter itself needs unity. When we talk about Taney's constitutional impact, we cannot avoid slavery. There is a core point here. Taney's disaster was not only that he stood on the side of slavery. More importantly, it was how he used judicial power to turn an issue that could still be compromised or delayed in politics into an issue that the Constitution has already answered for good. The most typical case is Dr. Scott v. Sanford in 1857. The background was that an enslaved man had lived with his owner in free territory, and after returning to a slave state, he sued for freedom. In Taney's majority opinion, he did three things, and each one was explosive in constitutional terms. First, he said black people were not part of the people as understood when the Constitution was made, so they could not be federal citizens, and their standing to sue in federal court was in doubt. Second, he went further and declared Congress had no power to ban slavery in federal territories, directly ruling the core logic of the Missouri Compromise unconstitutional. Third, and most fatally, he treated enslaved people as constitutionally protected property, and then used due process and property right logic to deny the federal government room to pass anti-slavery laws for the territories. If you place this inside the constitutional structure, this was not a narrow, text-conservative decision. It was an extremely hard judicial project. Taney was not satisfied with resolving the parties' dispute. He actively expanded the ruling into the national political structure and tried to use constitutional interpretation to shut down the argument once and for all. It was like he told the whole country, this is not something politics can negotiate. The Constitution has already decided it. The problem is that when social conflict is already impossible to reconcile, using the Supreme Court's authority to announce, no negotiation often does not produce obedience, it produces resistance. Northern public opinion treated it as proof that the court served the slaveholding elite. The South treated it as a legal weapon to legitimize slavery's national expansion. It directly weakened the political mechanism of keeping the Union together through compromise, and pushed constitutional conflict into a harder, more irreversible confrontation. Many people say the case caused the Civil War. Strictly speaking, no single case can be the only cause, but it did sharply lower the political threshold for war, because the space for compromise was nailed shut by constitutional language. Taney's constitutional path tied to slavery had been prepared even before Dr. Scott. The 1842 case Prigg v. Pennsylvania involved fugitive slaves. While the court recognized the basic framework of the federal fugitive slave system, it also made complex statements about whether states had to enforce federal mechanisms. The constitutional tension here was typical. On one side, the South needed federal power to help capture escaped slaves. On the other side, northern states used personal liberty laws to resist. Structurally, the court was deciding a key question. Can the federal government turn state governments into its enforcement tools? These issues continued and later extended into the federal-state confrontation before the Civil War. The 1859 case Abelman v. Booth directly targeted Wisconsin state courts trying to block federal enforcement of fugitive slave laws through state judicial actions. The Supreme Court emphasized that state courts had no power to interfere with federal courts or federal officials enforcing federal law. This ruling was very Marshall-like in constitutional style. It emphasized federal judicial supremacy and unity, aiming to prevent federal law from being broken apart piece by piece at the state level. Here you can see Taney's contradiction. In many areas he emphasized states' rights, but on the slavery line, he was willing to use federal supremacy logic to crush northern state resistance, because slavery needed a nationwide enforcement network to remain stable. After the Civil War began, Taney's constitutional drama entered its final act. He had a direct confrontation with the Lincoln administration over emergency powers. The most representative is Ex parte Merriman in 1861. Early in the war, the Lincoln administration authorized the military to arrest people suspected of undermining the Union in places like Maryland and suspended habeas corpus. Acting as a circuit judge, Taney ruled that under the constitutional structure, the power to suspend habeas corpus belonged to Congress, not the president. The president could not unilaterally cut off citizens' access to the courts. The constitutional argument here was actually clear. Emergency does not mean the Constitution disappears. Even in an emergency, the executive branch must have limits and authorization. But this time, Taney's constitutional logic ran into raw reality. The Lincoln administration largely ignored the ruling, and the military did not cooperate. The constitutional meaning is harsh. If political branches refuse to enforce a judge's decision, judicial power will show its structural weakness. If you see the Constitution as a machine, the Merriman case is like telling you this. In wartime, the engine comes from the executive and the military, and judicial checks can be crushed by reality. Taney insisted on legal boundaries in principle, but he could not provide an enforceable power solution, and he could not stop the nation from choosing survival first in a life-or-death crisis. So his late-life image carries a kind of tragedy. He spent his life opposing concentrated power. Yet when the country most needed centralized mobilization, he tried to use normal peacetime constitutional limits to restrain wartime executive power. The result was not victory, but the judiciary being pushed aside. Taney died in 1864, before the war ended. Even more ironic, soon after his death, the U.S. constitutional system moved in the direction he feared most. And in the most complete way, federal power grew sharply. Nationalization and centralization became an irreversible trend, and slavery was fully abolished. After the war, the 13th Amendment ended slavery. The 14th Amendment redefined citizenship and turned ideas like due process and equal protection into constitutional tools that allowed the federal government to step into state governance. The 15th Amendment further changed the structure of political power. From the angle of constitutional dialogue, these amendments were almost a point-by-point rebuttal of Taney's constitutional project. You said black people were not citizens. The amendments said they are. You said Congress could not limit slavery's expansion in the territories. The war and amendments ended slavery itself. You used property right logic to protect slavery. The amendments placed freedom and citizenship at a higher level, and used federal enforcement to compress state space. Taney's biggest historical function ended up being a kind of negative shaping. The more he tried to nail the old order in place through judicial power, the more the new order needed to break it open through war and constitutional amendment. So why is Taney seen as one of the most controversial figures in American constitutional history? The key is not a moral label like he did bad things. It is that he pushed the Supreme Court into a dangerous position. He tried to make the judiciary the final decision maker, and to decide for the whole country a kind of social structure conflict that cannot be ended by law in economic issues. He emphasized that public interest could break through old privileges, which sometimes made him look like a democratic anti-privilege judge. But in slavery, he did the opposite. He treated people as property and turned constitutional interpretation into a chain. So his constitutional legacy looks torn. On one side, it is a correction to Marshall-style federalism and an expansion of local public policy space. On the other side, it is using the Supreme Court's authority to legalize slavery's national expansion and destroy the political compromise mechanism in the end. He also tried to limit wartime executive power, but he could not make judicial decisions actually enforceable. Put together, you can see Taney is not a single-point failure person. He is a judicial line that runs through the contradictions of his era. He tried to nail society in place with law, and society used war to remake the legal structure. If we see the U.S. constitutional system as a long-running system, Taney's era is like an overload test. Marshall proved that the judiciary could pull the country toward unity. Taney proved that the judiciary could also push the country toward rupture. When courts use constitutional language to declare a social conflict finally settled, it may not bring stability, it may speed up collapse. The value of understanding Taney is here. You do not need to like him, but you must clearly see how he used judicial power, how he explained the Constitution, how he chose between the federal government and the states, between freedom and property, between order and morality, and how those choices then pushed the United States toward conflict, war, and constitutional change.